Hi there, I'm Jim Zirin. Welcome back for more conversations. We have a terrific show for you today. Dahlia Lithwick, the senior legal correspondent at the internet magazine Slate, is with us. Dahlia is, by my lights, the top legal journalist, author around, and she has written a terrific book about women in the justice system. The bestseller is entitled Lady Justice, Women, the Law, and the Battle to Save America. Daunting title. Kirkus calls the book required reading in the post-Dobbs world, and Julie Suk in the New York Times Book Review terms the work stirring, and indeed it is. We are delighted to welcome the scintillating Dahlia Lithwick to the program. Well, congratulations on your book. It was a great read. How long did you work on it?
I started it in 2017 and wrote it through most of 2021. And then I confess I had to do a very, very massive and substantial rewrite in the 4 days after Dobbs, that decision overturning Roe, came down in June. I had to rewrite huge parts of the introduction, the epilogue, and there's an abortion chapter. And so it was, as with most things, slowly and then quickly, got done in the very, very last days of June of this year.
Well, I'm glad you did it. Now, did you conduct interviews?
Yes, I interviewed most of the women who are profiled over the course of several years, and some of them multiple times.
I can congratulate you also in my Dubious Achievement Award. You were kind of called out by Judge Pryor of the 11th Circuit at a meeting of the Federalist Society. And what do you make of all that?
I mean, it's an interesting story. The Federalist Society, for folks who don't know, is this very, very powerful, very influential group of conservative legal scholars. It was originally constituted as a response to the feeling that legal academia was too liberal and lawyers were all too liberal. And it's been phenomenally successful under Leonard Leo, who was its visionary and leader, in selecting justices for the Supreme Court and opposing justices they don't like. $1.6 billion from a single donor went to the Federalist Society this fall. And you're quite right, at their annual conclave, somehow a good, fun thing to do was to have a life-tenured Article III judge insult a bunch of journalists, including myself, by name as the crowd hollered. I mean, I don't know quite what I make of it. I'm trying to imagine a liberal Article III life-tenured judge making fun of conservative journalists by name as the crowd laughed. But maybe I think the most interesting and telling thing is that what the chief judge of the 11th Circuit was maligning us for was writing pieces saying that the Federalist Society is very powerful and wealthy and influential. And so in some sense, the same institution that keeps being featured in puff pieces about how great and successful and powerful, and they seated 3 justices in the Trump era, and how incredibly sort of they have mastered the process of reshaping the judiciary. When progressive journalists call that out, then we're doing bad work. So I take your win, guys. That's my bottom line.
In the some 200 years of constitutional jurisprudence, judges interpreting the Constitution, women's rights have kind of come to the fore relatively recently. I mean, it was only 1873, which we think of as a long time ago, but it really wasn't. The Supreme Court of the United States said women have no constitutional right to be lawyers. They said the natural and proper timidity of the female sex prevents them from serving at the bar. And now, in the Trump years, you have women lawyers front and center in the fight to save what you call the soul of the country. All this has happened rather recently and rather quickly.
I think that's the central point I wanted to make with the book, Jim, was the idea that we live in a moment where we think it has always been thus, and it is actually only until very recently been thus. And you can just ask, folks can ask their mothers and their grandmothers how recently women couldn't hold a credit card in their own name, couldn't inherit property, couldn't, as you say, practice law, couldn't do all sorts of things.
Got the right to vote in 1920.
It's not so long ago. And in fact, one of the stories of the women's constitutional rights movement in this country has been that it was always kind of placed behind other rights that were seen as more important. And so one of the stories I wanted to tell was the story of how women kind of clawed their understanding of equal rights in the 14th Amendment, of equal justice and dignity, out of this sort of rock face that was quite unwelcoming to claims about gender equality. And that maybe, as you point out, rights that were very recently and not always generously conferred can just as swiftly been taken away, which is exactly what we saw in Dobbs.
Okay, so you write that women have a special relationship with the law. I take that to mean you think women bring something to the law that men don't necessarily. But then how do you account for women such as Amy Coney Barrett, such as Sidney Powell, such as Eileen Cannon, who seem to bring to the law a partisan bias rather than an observance of the rule of law?
I'm not so sure that I'd call it a partisan bias. I think I might say this is a willingness to reinstate and reify a patriarchal view of the world that has always existed. In other words, I think of Margaret Atwood in The Handmaid's Tale. Just as there are always handmaids and Marthas, there is commanders' wives. There are women who align themselves with traditional power structures, often for religious reasons, and we can talk about that. And so I didn't want to set out to make any claims that suggested that all women are going to be on the side of equality and dignity and feminism as I construe it. That would be way too broad a claim. And you're exactly right, there will always be outliers, just as there are outliers if you look at any vulnerable minority who wants to side with the majority against its own interests. That's always going to be the case. But I wanted to make the claim that there's a special relationship because women have, as we said at the beginning, fought so hard to etch themselves into ideas of liberty and equality that they can remember, almost with muscle memory, what it was like before that. And they can imagine maybe more urgently what it's like to lose it. And that knife edge, that's the special relationship. And this is by no means only true of women. I think, African Americans would say they have that same split screen relationship with the law, that they understand that it is both the agent and instrumentality of their equality and their dignity, but also of their oppression and vulnerability. That's the story I wanted to tell, what it is to live on the seam of law as the thing that makes you free and also makes you very, very vulnerable.
So you would argue that these outlying women just drank the male Kool-Aid?
Drank the male Kool-Aid, were instrumental in saying it's worth it to align yourselves with power, or, as I said, made decisions that are animated by either theology or animated by politics that say, I'm happy with structures that say, for instance, women can't necessarily exert control over their own bodies. It doesn't matter because they can just drop the baby off at the fire station and get on with their lives, the way Justice Barrett suggested at the oral arguments in Dobbs. Those may have deep, deep and abiding sort of constitutional and theological and political underpinnings, but it doesn't mean they are necessarily serving the interests of all women.
Okay, so let's talk about Lady Justice, this fascinating book. And it's been said you can't tell a book by its cover, but here you have a pink cover. Now, what's the significance of the pink cover?
I fought very hard to get my pink cover. I tell the story in the introduction of why I was writing, quote unquote, a pink book about the law. And what I say is that at some point, I've been covering the Supreme Court for 22 years. And at some point, a very esteemed and thoughtful constitutional law professor said to me, you've got all this, currency and capital that you've built up over the years as a legal analyst. Why waste it writing a little pink book about the law? In other words, why write about women? And I took that as something of a challenge because my view, and I think I say this in the book, is the law itself is a little pink book about the law insofar as it has forever animated the ways women can live their lives, the way women can work, the way women move through the world. It's just that it's a little pink book about the law written by men. And so what I wanted to say was, let's just own this. Let's own the idea that the law is instrumental in every piece of women's lives. And if that means throwing a pink cover on it to say, of course, the law affects every facet of our existence in every possible way, then let's make the cover pink.
Okay, so now the basis of our fundamental law is a written constitution. Many countries, like England, don't have a written constitution, although they claim they have a constitution. Now, our constitution was framed by white males. Most of them were slaveholders. The Constitution itself, I think in 3 places, approves of slavery, at least the 1789 Constitution does. With that as the basis, you don't see anything in the Constitution, particularly if you read the text, about marriage, about women, about equality for women, certainly nothing about abortion, certainly nothing about gay marriage. What can we really expect of our Constitution, particularly when it's interpreted by conservative judges?
I think there's 2 answers to that. One is that we can have a long conversation about originalism or original public meaning or, the toolkit that Justice Alito, for instance, brings to his Dobbs analysis, where he says, well, I checked, the word abortion is nowhere in the Constitution, so you're out of luck, right? And what that means in tension with the ideas about living constitutionalism or evolving constitutionalism, or the idea that, as you say, the Reconstruction Amendments profoundly change the original document and that history profoundly changes it again and again. So there's a cartoonish conversation we can have about whether we're really going to be in thrall for the rest of our lives to the framers and their ideas about freedom. And as you said, we would live in a very different world if, the ideas about freedom and equality as put forth by slaveholders, white landholding wealthy males, were the constraints that we all lived under. Most of us don't believe that that is the limit of the conversation, but I also think it ignores all the work that went into the Reconstruction Amendments, all the work that goes into attempts over the years to modify and rethink the Constitution to confer rights that the framers would never have thought about. And so whether, as you say, it's Obergefell and LGBTQ rights, whether it's Loving versus Virginia, doing away with the anti-miscegenation laws that said you couldn't marry someone who wasn't of your race. So I like to think that outside of the very simple cartoonish debate about whether we believe in an originalism or a living constitution, there is simply the way we all move in the world, which is nobody thinks that the framers' ideas of cruel and unusual punishment are fixed in time. Nobody thinks the framers' ideas of what equal protection meant, because that's insane. We all believe in some sense that in a world with cell phones and Twitter, the rules as set forth in the founding documents are a guideline, and I don't think even the most stringent originalist believes otherwise. And I think in some sense this debate is a distraction from a meaningful conversation about what are the tools we would all use to get to a broader, more capacious understanding of the founding documents. And so I almost don't want to take the bait and get into a fight with Justice Alito about whether the word abortion could have appeared in the Constitution. Of course, it could not have. I want to get into a much more nuanced debate about whether we could ever agree upon a methodology of constitutional interpretation that could be open enough to kind of allow dignity and equality for everyone.
Well, of course, it all started with Scalia, who was the granddaddy of originalism. And he used to say the Constitution is dead, dead, dead. If you have a living Constitution that evolves, Clarence Thomas, famous for saying to his clerk shortly after his appointment, I ain't evolving. If the Constitution is dead, then you have 1789. It was a crime to kiss your wife in public on Sunday, and they threw you into the stocks for 30 days. Now, today, most people would think that was cruel and it was unusual. Not so then. Scalia would say, well, stupid, but constitutional.
But maybe you've just hit on, I think, the most interesting problem we have with the sort of modern day originalists. Justice Scalia, you can quibble with his methodology, but I think the principle that he put forth for his view of originalism, which was lashed to original public meaning, was that he wanted a constraint on judges. This was, in his telling, a way to make sure that judges weren't making stuff up as they went along, right?
So he didn't trust them, and probably he was right.
Well, he didn't trust them, but what the paradox of this moment is, we are sitting a few months after the Supreme Court fundamentally changed Second Amendment law, ignoring precedent, fundamentally changed, as you said, abortion law, overturning 50 years of precedent, fundamentally changed the laws about church and state, and the line between those two things, undermining the Lemon Test, fundamentally changes, agency law. Time again, the Supreme Court says, no, not that. So it's the opposite of judicial humility. What they're now doing, I think, does such violence to the animating idea that Justice Scalia had, which is we want judges to do as little as possible, and we want a unifying theory of how they get there. Now we have, under the banner of originalism, the court just willy-nilly overturning decades, in some cases centuries worth of precedent, and saying, oh, we're just doing minimalist Scalia work. And so I think what you've just identified sort of puts the lie to the project of originalism. This was never meant to be balls and strikes. This was never meant to be minimalism or judicial humility. This is a big swing enterprise that really seeks, I think, to turn the clock back 200 years.
Okay, so let me put your feet to the fire. Your bête noire, Justice Kavanaugh, at the oral argument in Dobbs, said, yeah, but often it's necessary to overrule precedent when it's wrong. We overruled Plessy v. Ferguson with Brown v. Board of Education. We overruled cases with Obergefell, the gay marriage case. We overruled Lawrence v. Texas, overruled the prior case that said that homosexual acts could be criminalized, even if conducted between consenting adults in private. And we'd be a very different country if we hadn't overruled those cases. So what's the difference between what the court did in Brown v. Board of Education and what the court did in Dobbs?
I mean, there's a simple answer and a complicated one. The simple answer is that Dobbs is the first time the court overturns a major constitutional case in order to take away rights as opposed to confer rights. So every case you've described actually says, oh, we made a mistake because we had a much too myopic view of freedom, right? And that's Obergefell, and that's Loving, and that's Brown v. Board, and that's Plessy, and that's Korematsu, right? Every one of those cases gives more freedom rather than takes it away. That's the simple answer. I think the tricky doctrinal answer is nobody says the court should never overturn cases. But we have a roadmap and a set of rules that really determine how and when a court can overturn precedent. And the court adhered to none of those in Dobbs. The court didn't go through the factors for overturning precedent and say, bing, 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 bing. The court just said, nah, this was wrongly decided, and now we're changing it. I think the thing that they ignored most pointedly among the factors that go into overturning precedent is this idea of reliance, right? That the world has come to rely on this holding. And Justice Alito brushed it off as though it was so immaterial to him that 5 decades worth of women and people who could get pregnant had come to rely on the holding in Roe. We can quibble again about how it was decided, and people like to sort of reverse engineer it and say it should have been rooted, in equal protection and not substantive due process. We can have that conversation, but the point is that generations of women have organized their lives in reliance on the promise of Roe. And Justice Alito, in addition to citing famous witch burner Matthew Hale, also just made absolutely no attempt to engage with the economic, the medical. There was extensive research in this case in the amicus briefs about the ways in which women would be materially harmed going forward if they lost the protections of Roe, and all the ways in which they relied on Roe in order to construct their economic and their family and their social lives. And to simply say, oh, we don't care, that's actually not doing the work that you have to do if you're going to overturn precedent.
Okay, let's talk about some or all of the 8 women whom you profile in your book. All were very active during the Trump era, overturning the travel ban, establishing voting rights, establishing abortion rights, despite all sorts of constraints. At the time, there was a constitutional right to abortion. What is the common thread there? Why do you see those rights as having been vindicated by activist women? And you have one woman who concluded that maybe women should not be so active in the law. Maybe they should be active organizing and engaging in political activity.
I mean, the book, you've absolutely identified the arc of the book. The book starts with sort of good Law and Order kind of courtroom drama, because everybody loves those stories. And so there's lots of like, dun, dun, stories of women who go into court and prevail. And
with the woman as Perry Mason.
Right, because, and by the way, Sonia Sotomayor says that was what animated her desire to be a lawyer and ultimately a judge, is watching Perry Mason. There's a lot of power in those stories.
But she became a DA, so.
Right, the opposite. But I think that one of the things I wanted to say was, the book sort of halfway through turns, as you say, to organizing and turns to political activity. Because I wanted to make the point that you can win all these cases, win and win and win, but if you're not changing sort of democratic structures, whether it's one person, one vote and gerrymandering, whether it's vote suppression, whatever it is, if you're not doing that work, you're going to lose in the aggregate. And so halfway through the story, you're quite right, it goes from a narrative about winning in court to a narrative about what we would need to do to have truly representative democracy. And it goes back to your initial framing, which is democracy was not constructed by white male slaveholders to be fully representative democracy, right? That's why we have a malapportioned Senate. That's why we have the Electoral College. That's why we can still gerrymander. And so the work that I was really interested in, it's why the book ends with Nina Perales at MALDEF and Stacey Abrams doing work in Georgia on vote suppression, is because I think the real work for women lawyers isn't just going to be vindicated in the courtroom. It's going to be vindicated when the machinery of democracy itself is making sure that everyone's vote counts.
And let's not forget Dahlia Lithwick and the culture of silence, which occurred during the Trump era. It was illustrated by the Harvey Weinstein case, probably the Jeffrey Epstein case, and there's discussion of that. But unfortunately, we've run out of time, So, because we could go on for some time, it's been a fascinating discussion, and I'm grateful to you for it. But I have a question for you, and the question is, looking at Lady Justice today, do you see a thumb on the scales?
I am looking at Lady Justice in the wake of the midterms. And I look at the midterms and I think, holy cow, the thumb on the scale on the one hand is a 6-3 supermajority at the Supreme Court that doesn't seem super interested in protecting and preserving women's equality and dignity. And then this tsunami of women who came out and voted in violation of that idea, who came out and said, we will be heard, we will be seen, and who I think really did change the world. And so I think it's a story for me. I guess this is a long way of saying, Jim, if the midterms had not been a story of women just surging into the void and saying to Justice Alito, you said we are not without electoral power in Dobbs. Look at me, I'm here. Because I think that's an amazing story. And so to me, the thumb on the scale is the blueprint that we have from history and from the women in the book, which is never say never, because women have been showing up for equality and for dignity for decades, for centuries, and they will keep showing up going forward.
Women will rise again.
They will rise again.
So, Dahlia Lithwick, thank you so much for coming by. And thank you for coming by. Tune in next week for more conversations. I'm Jim Zirin. Meanwhile, please visit our website at conversationswithjimzirin.com. Take care, be well, and all the best.